Let us look into the Interpretation Act of Canada. It states in the Interpretation Act that the duality of legal traditions and application of provincial law, both the common law and the civil law, are equally authoritative and recognized sources of law, of property, and civil rights in Canada. So an individual can call upon common law rights, or an individual can stand upon civil law or civil rights in Canada. Now, common law in Canada now flows through the Constitution Act of 1982. The Supreme Court has made it clear in cases M.A. versus Ryan that the common law must develop in accordance with the Charter values. A trespass in common law equals an infringement or denial of a fundamental right or freedom. So in order to bring forth the fact that your common law rights have been infringed or denied, you must prove that your charter rights, the rights and freedoms afforded to you and guaranteed to you through the charter, have been denied or infringed. Canada, as defined in the Constitution Act 1867, Article 91, is a body corporate operating under executive powers. The Supreme Court of Canada has made this ruling. It stated, further, although Section 91.1 of the Constitution Act 1867 gave the Queen the power, with the advice and consent of the Senate and the House of Commons, to alter the Constitution of Canada, except in certain expressly designated areas, it does not confer a power to amend the BNA Act. The word Canada in Section 91.1 of the Constitution of 1867 does not refer to Canada as a geographical location or unit, but refers to the juristic federal unit. The term juristic federal unit brings forth or indicates that Canada is an artificial entity, the corporate body. When you look into black laws under the word juristic person, it tells you to go and see the word artificial person. Then, when you look at the definition or meaning of the word artificial person, it states this: an entity, such as a corporation, created by law and given certain legal rights and duties of a human being, a being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. Canada does not mean a geographic location. Canada means an artificial person in law. Canada means a corporate body. Canada refers to a corporation. So when we look back into the Interpretation Act of Canada, we understand what's being brought forth here now. The Canada in the Interpretation Act is that body corporate, the corporation. And in that corporate body, in that corporation, common law and civil law are equally authoritative when we seek to express our rights and our freedoms. I am being forced into recognition as an officer of Canada, the class of person before the law, contrary or against my full legal capacity. When you look into the provincial enactments, the provincial laws, now this happens all across Canada. If you live in a municipality, a town, a township, then you are considered to be inhabited in that territory. And as an inhabitant of that territory, you have been incorporated into the corporate body, into the corporation. Now, Ontario Municipal Act, municipality means a geographic area whose inhabitants are incorporated. Municipality is a body corporate. The inhabitants of every municipality are incorporated as a body corporate. So if you live in Toronto, for example, you're in the municipality of Toronto, then the name of the body corporate is called Toronto. And you have been, as an inhabitant, incorporated into the body corporate, into the corporation, and you are now considered an officer of the corporation. And you are subjected to their rules and regulations, their bylaws, if you stand as that class of person. Charter of Vancouver, City of Vancouver. The inhabitants of the area, the boundaries of which are described in this section, shall continue to be a corporation and a municipality with the name of the City of Vancouver. New Brunswick, Article 2, Municipal Enactment. The minister shall administer this act and may designate persons to act on his behalf. The inhabitants of the cities and towns in existence on January 1st, 1967, continue to be bodies corporate. The inhabitants of a municipality created under this act are a corporate body or a body corporate. Once again, Nova Scotia Municipal Act. Every municipality subject to this act, every municipality doesn't leave out any room for nothing, for one. Every means all. Every municipality incorporated at the date this act comes into force is subject to this act. The inhabitants of the county of Cape Breton are and continue to be a body corporate, and the inhabitants of the county of Queens are and continue to be a body corporate under the name Region of the Queens Municipality. Let's go over to the justice.ca website, Canada's justice system, and see what they have to say about the term body corporate. This is from their website directly. You can get there from this link. I might post it below on the video at YouTube. So, a body corporate law. The term corporation should be used instead of body corporate. So everywhere where we see the term body corporate, the term corporation should be used instead of the word body corporate. So the municipality in Ontario, the inhabitants of every municipality are incorporated as a corporation. It says it clearly in Vancouver, the inhabitants of the area continue to be a corporation. In New Brunswick, the inhabitants of the cities and towns continue to be corporations. Municipality in Nova Scotia, the inhabitants of the county of Cape Breton are and continue to be, instead of the word body corporate, we replace it with corporations. So we see from the beginning, Canada is referring in law to a corporation, a corporate body, and then each and every subsequent municipality, wherever we live, we are considered to be part or incorporated into the corporation. Continuing on with the justice system, the terms body corporate and corporation mean exactly the same thing. However, the term body corporate, it's outdated. It is never used in business and financial writings, which deal with the corporations at great length, and does not appear in either the Canadian Oxford Dictionary or the Gage Canadian Dictionary, although other dictionaries do list it. Indeed, the very unfamiliarity of the term body corporate may mean that not all readers realize that it means the same thing as corporation. So again, the justice system is declaring, when you see the word body corporate, it means the same thing as a corporation. And all of us as inhabitants of a geographical area have been incorporated into these corporations without our consent and without our knowledge. Body is a noun and corporate is an adjective. In English, adjectives generally go before the nouns they modify. Body corporate is one of a small number of expressions in which the adjective follows the noun. This construction was fashionable in Elizabethan times, but needless to say, it is no longer common. However, not only is body corporate not current in modern English, but also it does not have a particularly technical meaning. It simply means corporation, as is clear from the following definitions. So this is the justice system talking about the definition of what a body corporate is, telling us that it means corporation, and now they're going to back up their point. And what do? They go into dictionaries, into legal dictionaries. So they quote the New Oxford Dictionary of English. Body corporate, formal term for corporation. They go into Blacklaw's Dictionary, the 8th edition, and they look at the word body corporate, where it tells them to see corporation. So how come it's okay for the justice system, when they're seeking to define words and define definitions, to go into legal dictionaries and bring forth the definitions, but when individuals across Canada or the United States of America do the same thing, then they want to label them as paper terrorists and say that they're making trouble for the justice system. It's too funny. So back to the point at hand, we are all being incorporated into the body corporate and are being classified as a class of person, an officer of the corporation, which is a personality that owes duties and obligations to the executive powers of these corporate bodies. So this is the mechanism or the operation of law that they're using against you. Because they claim that you are incorporated into their corporation, then you are considered an employee, an officer of the corporation. You're not the manager, you're not the executive power, you're not the owner. You're just a simple employee of the corporation. And as such, you are subjected to the rules and regulations, to the powers of the executive branch of the corporate body. So when municipalities try to apply bylaws against you or taxation against you, the operation of law that they're using is they're claiming you are an officer of the corporation and you are subject to their regulation. You are subject to these laws because you are in that class of person. You are operating from that personality. Personality. The definition of personality is brought forth as such: the legal status of the one regarded by the law as a person. The legal conception by which the law regards a human being or an artificial entity as a person, also termed legal personality. The enactments and regulations, better known as statutory powers, are forcing legal personality upon you, which limit and abridge your full legal capacity. So let me talk about a little bit of legal personality. When you operate in your motor vehicle and you are driving the motor vehicle, the legal personality you are operating from is driver. When you're going to school, secular education, and you're taking courses, the legal personality you are operating from is that of student. When you go to the hospital when you're sick and you seek medical attention, the legal personality you are operating from is that of patient. When you pay taxes, the legal personality that you are operating from is that of taxpayer or officer operating an office of Canada. So in every action that you do, whether it's driving, going to school, paying taxes, even playing sports, it doesn't matter what you do. But in every capacity, they've afforded to you or given to you legal personality. And they've given a title or a designation to that legal personality. Again, you're in your car and you're driving, your legal personality is considered the driver. Now, these legal personalities are controlled by enactments and regulations. When you're operating as a legal personality, you can only exercise rights and duties that the enactment allows you to do. Now, your fundamental rights and freedoms, your full legal capacity are being abridged when they force you into playing these legal personalities. Going back up, when we look into the municipal acts, their legal personalities that they're forcing us into is that of officer of the corporation, officer of the corporate body. And by doing that, they are limiting and abridging our full legal capacity. They place us into the capacity of the class of person as the officer of the corporation, and then they try to control and regulate us through the enactments and regulations by claiming that we owe the obligation to the enactment. As we saw above, the municipal acts are forcing you to act as a legal personality, a class of person, designated an officer of the corporation, by incorporating you into their body corporate without your consent and without your knowledge. These statutory powers and the operations of law flowing from them are limiting and abridging our full legal capacity, as guaranteed to us through the Constitution Act of 1982. Now, in the court judgment titled Thomson Newspaper Limited versus Canada, the judge brought forth the following: while individuals, you and I, as a rule, have full legal capacity by operation of law alone. Artificial persons, classes of persons, are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. You and I are born into existence, and by the right of birth, we have something that is designated or recognized as full legal capacity. This is an expression of our natural rights, our fundamental human rights and freedoms. And we have this by operation of law alone. It is considered the rule of law. And these rights and freedoms can only be removed from us or limited from us in accordance with the Charter. The State Party Canada cannot just decide to take away these rights and freedoms. They must respect international law and they must respect Charter law. So individuals, by operation of law alone, have their full legal capacity. And you and I, as I said, from the time of birth, this capacity was recognized. It's there for us to exercise. An artificial person, the class of person, the driver, the student, the patient, the officer of the municipal corporation, this is created by law. You see the definition? This is created by law through the enactments and regulations. And when you operate that legal capacity, you are only given certain legal rights and duties of a human being. You cannot operate your full legal capacity. You can only operate certain rights and freedoms, and these rights and freedoms, again, are given to you through the enactment, through the statutory power. Artificial persons are creatures of the state, created by law, and they enjoy civil rights, not common law, civil rights and powers only upon the approval of statutory authorities. You sign yourself up, you get a driver's license, you're considered a driver, your legal personality is a driver, you are then controlled by the Highway Safety Enactment. That class of person is controlled. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. Now remember, when they define natural rights, fundamental rights and freedoms, human rights, they always give an example after their definition of what these rights represent, and they always talk about life, liberty, and property. Under our natural rights, we have rights to life, liberty, and property. And we don't owe any duty to the state, but the state, under common law, owes a duty to us. To what? To protect our life and to protect our property. Now, they have many obligations as it pertains to property, and I'll just briefly speak about it, how they're failing. Right now, through incorporating you into their local corporation, in the municipality that you live in, they are taking away your full legal capacity and taking away your property rights. They are saying that they have the right to administrate your property and tell you what you can and cannot do with your property. While under common law, under your full legal capacity, nobody actually has the right to tell you what you can and cannot do with your property as long as you do not harm anybody. But they don't recognize you as a human being, as a man or woman under your full legal capacity. They recognize you as a personality, a legal personality, a class of person, the one who is incorporated into their corporation, and as such now, they control what rights you can exercise. And they say you can do such and such with your property if you follow our rules and regulations. This is what they're doing. That's the operation of law that they're using against us. Now, his rights, our natural rights, are such as existed by the law of the land long before the organization of the state, and can only be taken away from us by due process of law and in accordance with the Constitution. We owe nothing to the public so long as we do not trespass upon their rights. Our rights existed long before Canada became a dominion, and our rights and freedoms, our fundamental rights and freedoms, our full legal capacity can only be taken away from us through due process of law, which is a proper principle of justice, and it must be in accordance with the Constitution. And by default, it must be in accordance with international law. And when you study international law, and when you study the Constitution and domestic law, you will see that we have many fundamental rights and freedoms that are never to be limited or abridged, even in a time of national emergency. And you can go check the preamble for the Emergencies Act to find that clear and concise statement. We have full legal capacity by operation of law alone. We can exercise our fundamental rights and freedoms. And remember, the judge has already declared that our full legal capacity, our fundamental rights and freedoms, they operate long before the state party Canada became a dominion. They exist by the law of the land, not by the law of a legislator. Now, as a class of person, given legal personality, we can only exercise the rights and duties brought forth in the enactments. The enactments become the controlling mechanism against us. These enactments violate our full legal capacity by forcing us to play or enter into the role of a class of person and limiting our ability to exercise our common law rights, our fundamental rights and freedoms, our human rights, our full legal capacity. The executive powers and the legislators are under obligation to respect and ensure my individual rights and freedoms, my full legal capacity, as enumerated within the international covenants and the Constitution Act of Canada. And in the Constitution Act of Canada, Article 52, it states that the Constitution Act is the supreme law of Canada, and any statutory power, any enactment or regulation that violates my rights that are brought forth in the Constitution Act of Canada is of no force or effect against me. It has no operation of law to hold me or to bind me. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. This is Canada, the Attorney General versus Sam Levey and Associate in 2005. First, and most importantly, the Constitution is, under Section 52 of the Constitution Act, the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. The invalidity of a legislative provision inconsistent with the Charter does not arise from the fact of it being declared unconstitutional by a court, but from operation of Section 52 alone. Thus, in principle, such a provision is invalid from the moment it is enacted, and a judicial declaration to this effect is but one remedy amongst others to protect those whom it adversely affects. So what the judges are saying, that if they pass an enactment, if the executive powers of this corporate body called Canada, if they pass an enactment that breaches your full legal capacity, that limits and abridges your fundamental rights and freedoms, it's of no force or effect against you the moment it's enacted. And running to court and getting a judicial declaration to this effect is only one remedy that you have available to you to use. DeVito versus Canada, Supreme Court of Canada. Canada's international obligations and relevant principles of international law are also instructive in defining the right. So Canada has to go into the international covenants in order to define the right, in order to see what right, what freedom is being expressed. Can they limit it? Can they abridge it? Or are they not allowed to? The content of Canada's international human rights and obligations is, in my view, an important indicia of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents. International law is instructive in defining the right. The full benefit of the Charter protection must, as found in the international human rights documents, including the ICCPR and the ICSECR, they must protect you as much as the international human rights document does. It must protect the individual's fundamental rights and freedoms. So when they created the Charter, they were under obligation to make sure that the Charter of Rights and Freedoms brought forth our rights as defined in international law and protected us as individuals from being forced to play the role of the legal personality of the class of persons, thereby limiting and abridging our full legal capacity. Now, no state party or actor, no one representing the government, has the right to take actions against us that would violate the protection of the Charter and international law concerning our human rights and freedoms, our full legal capacity. By using enactments such as the Municipal Act and the operations of law contained therein, the executive powers of this corporate body, designated Canada, are limiting and abridging your fundamental rights and freedoms. You owe no duty to the state as mentioned above. However, through forcing you into recognition as a class of person who owes a duty to the enactment, the state party is placing obligations and duty upon you to force your servitude and to bring you under their statutory powers. Now the courts have already made it clear that they are not to take actions against us. They are not to use statutory powers or enactments or create enactments, the executive powers of Canada, that limit and abridge our charter rights. The reference in Section 32 to the Parliament and the legislator make clear that the Charter operates as a limitation on the powers of those legislative bodies. Any statute enacted by either Parliament or a legislator which is inconsistent with the Charter will be outside of the power of the enacting body and will be invalid. So here's another judge stating the same thing. If you enact a law, if you bring forth enactments and regulations that breach our full legal capacity according to what is guaranteed and protected in the Charter, then it will be invalid. And when we look to the judgment before, it said a judicial declaration, declaration of the courts, is only one remedy that you can seek if this is transpiring against you. It goes on to further state, it follows that any body exercising statutory authority, for example, the governor in council or lieutenant governor in council, ministers, officials, municipalities, school boards, universities, administrative tribunals, and police officers are also bound by the Charter. Action taken under statutory authority is only valid if it is within the scope of that authority. Since neither Parliament nor a legislator can itself pass a law in breach of the Charter, so they're not supposed to create enactments, they're not supposed to create domestic law, regulations that breach the Charter, that limit and abridge our full legal capacity. Even if they do, then the ones who operate in these offices are not supposed to take actions which breach or limit our full legal capacity. He goes on to say neither body can authorize action. Now they're not talking about law anymore. Now they're talking about deed. Now they're talking about action, which would be in breach of the Charter. Thus, the limitation on statutory authority, which are imposed by the Charter, will flow down the chain of statutory authority and apply to regulations, bylaws, orders, decisions, and all other actions. So everything that this state party can do to you or against you is controlled by a statutory authority. And if whatever statutory authority they are using, if it is limiting and abridging your charter rights, your fundamental rights and freedoms as protected and guaranteed in the Charter, as brought forth in international law, then it's of no force or effect against you. You do not have to submit to it. You do not have to be bound to it. You do not have to allow it to control you. Now that statement that I just said does not refer to common law as it applies within the Criminal Code of Canada. If you harm somebody, if you steal from somebody, if you breach common law as defined within the Criminal Code of Canada, because some of those sections refer to the common law and some to statutory regulations, you will be subjected to the punishment and the powers of this state party, because man decided those rules, not legislators. This is R versus Wagner. In 2015, this judgment came out, talking about the rule of law. Not rules of law, not enactments and statutory powers, but the rule of law. Remember, we read it before. The rule of law is what? An individual has full legal capacity by operation of law alone. We owe no duty to the state, since we receive nothing therefrom, beyond the protection of our life and our property. So R versus Wagner, the rule of law. The idea that there are certain fundamental unwritten principles that govern all members of society, including the legislators, and which judges are expected to enforce is not particularly new. The contemporary concept of unwritten constitutional principles can be seen as a modern reincarnation of ancient doctrines of natural law. So here the judge is stating that it's not a new idea that there are certain fundamental rights and freedoms that control all of society, that control legislators, and that judges are expected to enforce. They are expected to enforce our full legal capacity. When you understand the court system was there first and foremost under inherent jurisdiction, under common law jurisdiction, to enforce our full legal capacity. Secondarily, it's there now for commercial purposes. Now, natural law is a physical law of nature, a philosophical system of legal and moral principles, purportedly deriving from a universalized conception of human nature or divine justice, rather than from legislative or judicial action. A natural right, a right that is conceived of as part of natural law, and that is therefore thought to exist independently of rights created by the government or society. And now these natural rights are the right to life, liberty, and property. So these natural rights that exist independently of the government since 1976 have been acknowledged and have been guaranteed, not created, but guaranteed and acknowledged to us in the international human rights, such as the international covenants. And subsequent to that, within our domestic charter, the Charter of Rights and Freedoms. Our natural rights were contained, were brought forth, were placed into the charter in order to provide a mechanism of protection for us if the government executive power tried to limit or abridge them. Now, an inalienable right, a right that cannot be transferred or surrendered, a natural right such as the right to own property. So an inalienable right, again, it's a natural right, and what is it? They give us an example, the right to own property. An absolute right, a right that belongs to every human being, and such as the right of personal liberty, which is a natural right. So all these natural rights that work together to make our full legal capacity, which operates by law alone, which operates on the land alone, without the permission of the legislator, is something that is now protected on our behalf. The Chief Justice, now notice it's not a judge or a master, this is the Chief Justice talking, goes on to note that these rules bind the legislative, executive, and judicial branches. The debate is not so much about whether such norms exist. Why can the Chief Justice say that? Because these norms are fundamental rights and freedoms, human rights, natural rights, common law rights, are now expressed and contained in the international human rights documents and within the Charter. So the existence are there. So there's no argument there. But what the argument is about, what are the norms in relation to any given case where a litigant calls on such norms to his aid? So how do you give effect to these rights, and how does a litigant express himself to show that his full legal capacity has been violated, has been limited or abridged? I intend, in my next couple of videos that are to follow this one, to go through this very operation of law. What is the obligation upon an individual when standing before the judicial system in order to express and show forth that his full legal capacity has been limited and abridged? Now the Chief Justice goes on to say, finally, at the developing fringes of the new natural law, which goes by the name of human rights, are other assertions. It, rests on the proposition that there is a distinction between rules and the law. Rules and the rule system can be good, but they can also be evil. So when they use rules and the rule systems, enactments, and regulations to confer upon you legal personality, to place you into the position of a class of person, and then strip you of your full legal capacity, your fundamental rights and freedoms, the judge says that this is evil, that these rules, they can be good, but they can also be evil. And they are evil when the state party forces you or forces them upon you and does not allow you to operate under your full legal capacity. Because under that capacity, remember, you owe no duty to the state. But now they're trying to use rules and a rule system to make you owe obligations to them. Thus, as important as these principles may be, and as essential as it may be, that in difficult cases, the judge must stand against the winds and the rains to uphold them. So the Chief Justice is telling the judges, you are expected to stand against the pressure of the statutory powers, against the pressure of the executive powers, against the pressure of the judicial system that's working on behalf of the executive powers, and you must stand against these winds and rains, and you must uphold full legal capacity. So judges are expected to stand against the winds and the rains to uphold our full legal capacity. But don't forget also, R versus Hape says that these judges, when we go before them, they're under the presumption that the enactments and the regulations conform to the charter. And it's up to us to prove to them that it does not conform to the charter, that these enactments and regulations are limiting and abridging our full legal capacity. And the judges are only under the presumption that all these enactments and regulations conform to the charter, because in the Justice Act, Article 4, the Attorney General is supposed to examine all these bills, and he signs off on them and says, yep, they conform to international law, they conform to the charter, therefore we're giving it force of law. Therefore we're going to allow it to operate here in Canada. But he was under obligation to make sure that they don't violate our full legal capacity. So when we stand before the judge is standing on the signature of the Attorney General, thinking that the enactment conforms to international law and to our charter rights and freedoms. And on that point, recently in 2014, there was a Crown attorney, it was a big story that was going on in Canada and is still ongoing, that used to work for the Conservatives, that is now suing the government of Canada because he claims that a lot of the enactments and legislative rules that are being put in place are limiting and abridging our charter rights, and they are still signing off on them anyways. So someone from the inside is standing up and fighting, which is good. Now, those unwritten principles tend to be largely replicated in the text of the Constitution, which Section 7 of Canada's Charter of Rights striking me as a prime example. Our written Constitution. So he's talking about unwritten principles that bring forth natural law, natural rights, common law rights, fundamental rights and freedoms, human rights. He's talking about they are unwritten principles. However, now in 2016, they are contained in the international law, in international human rights, in the international covenants, and they are contained in Canada's Charter of Rights and Freedoms. They are actually written down for us, guaranteed to us, so they can protect us. Our written Constitution reflects many, many influences, including the drafter's awareness of natural law. So he's saying that the ones who made up the Canada's Charter of Rights and Freedoms, they were aware of natural law, and they contained many provisions for us to defend our fundamental rights and freedoms. Now remember, the first article of the Constitution states the following. It says that the Charter only guarantees certain rights and freedoms. The Charter never claims to guarantee all our fundamental rights and freedoms. The Charter never claims to protect fully our full legal capacity. It says only certain rights and freedoms. However, in Article 26 of the Charter, it says Canada does not deny other rights and freedoms that exist in Canada that are not mentioned or that are not protected in the Charter. So the Charter is a complete expression to protect our full legal capacity, even though it doesn't outright say it. Now, the Chief Justice goes on to say, I agree with her that the rule of law is, quite apart from the terms of any written constitution, part of the constitutional DNA of this country. So he says, even though it's written down, even though we have it expressed in Section 7 of the Charter of our natural rights, our fundamental rights and freedoms, he says, even if it wasn't written down, it's still part of our constitutional DNA. It still represents the fundamental principles and fundamental precepts of this country. Why? Because Canada was based upon that. Canada was built upon common law. As we saw in Article 8.2 of the Interpretation Act, both common law and civil law are both authoritative in Canada. And long before all these enactments and regulations came into play, long before the legislator of Canada began to create all these controlling mechanisms, common law, the law of the land, was in existence and abided and ruled. Even though we couldn't enforce these common law rights. Remember, R versus Haynes. It says prior to the Charter's advent, an individual really had no means to enforce if the legislative or executive government came against him and removed their full legal capacity. But since the advent of the Charter, now we have the ability, now we have the capability to go against the executive powers and say you're using an enactment, you're forcing me into a class of persons, you're conferring upon me legal personality that limits and abridges my full legal capacity. And as such, I won't stand there. As such, I won't take the responsibility as that class of person. Now again, he says, part of the constitutional DNA of this country and that its precepts, natural law, must be abided by and must be applied by the judges. So he's telling them, again, this is, if you look at the Chief Justice, he's the manager. Okay, he's the president of the judicial system, of the judges of the judicial system. And now he's telling them what's going on. And this is in 2015. Why do you think a case like this, a judgment like this came out in 2015? Well, let's speculate a little bit, because there are many individuals all across Canada now that are waking up to their full legal capacity, to the fact that they have fundamental rights and freedoms that the government is limiting and abridging, and they are going before the masters, and they are going before the judges of the courts. But the judges and the masters are ill-equipped. They don't have the knowledge or the understanding to deal with these cases. So the Chief Justice is laying into them and telling them, listen, when they come before you and they're standing on their full legal capacity, it's expected to you that you stand and you help them. The rules that they're using, the statutory enactments, they can be evil. They're stripping them of their full legal capacity. And it's up to you as the judge to stand against this and to uphold natural law, to uphold fundamental rights and freedoms. This is the reason for the justice system. The reason for the justice system is not there to uphold statutes and enactments and regulations. Yes, they can, secondarily, as long as they do not breach our full legal capacity, as long as they do not strip us of our fundamental rights and freedoms. If these enactments and regulations are stripping us of our fundamental rights and freedoms and are removing our full legal capacity as protected in the Charter and in international law, then the judge is expected to stand up and make a judgment against the executive powers for the individual. The judge goes on to say, its precepts must be abided by and must be applied by the judges, no matter how strong may be the prevailing winds or how challenging the social or political environment in which an issue arises. It doesn't matter the context of the question. It doesn't matter the context of the challenge, how much pressure it's going to put on the social system or how much pressure it's going to put on the political system. It's up to you to stand up and stand against the winds and the rains and protect the individual's full legal capacity. If the enactment, such as the municipal enactment, is placing an individual into a corporate personality, making them play a class of person without their consent, without their recognition, without their knowledge, this breaches Article 7 of the Charter of Rights and Freedoms. Everyone has the right to life, liberty, and security of the person. They have the liberty to decide if they will be part of the corporate body of Canada or the corporate body of the municipality. No, McDonald's cannot come to me today and force me to be their employee. Kentucky Fried Chicken cannot come to me today and force me to be their employee. An investment firm cannot come to me today and force me to be their employee. The RCMP police force, they're a corporation under law. They cannot come to me and force me to be their employee. They cannot force me to take legal personality. They cannot force me to play the class of person that they play. So why does Canada try it? Why do the municipalities try it? And why do some of these judges who are unlearned think that they should stand up and defend the breach and the limitation against the individual when your own boss is telling you, hey, wake up, Charlie, you shouldn't be doing this. You're under obligation to respect full legal capacity. And if these people are coming before you and they're showing you that the enactment is limiting and abridging their fundamental right and freedom, you've got to stand against the wind and the rain and protect them. We have the right in Article 16 of international law that says we have the right to recognition as legal personality. We have the right to take recognition as a class of person. A right does not produce an obligation. You cannot point to your domestic law. You cannot point to your municipal acts and say because the municipal act says you will take legal personality, you will take recognition as being incorporated into the corporate body, then you are forced to do so. No, that breaches Article 16 of international law, that breaches Article 26 of the Constitution Act, and therefore your enactment, your statutory power, is of no force or effect against these individuals that are claiming their rights. The ones who are unaware, the ones who are sleeping, the ones who know nothing about what is transpiring against them, then you hold them in ignorance. But the ones who come at you and express their rights and expect their full legal capacity to be upheld, that is your obligation. R versus Peel Regional Police Force, Chief of Justice, 2000. The courts, too, must conform to the rule of law. The rule of law is the very foundation of the Charter. It stands to reason, then, that the courts are duty-bound to apply the Charter. Now, I'll leave it at that in this video. And as I said, in my next few videos that come out, I'm going to show you exactly what is our responsibility before the justice system. If we go in there as an individual claiming that the rule of law has been broken, that our full legal capacity is being limited and abridged, what is it that we must do in order to show the judge that we are right and have the judge produce a remedy on our behalf? Now, again, this is not the only option. This is not the only road. This is not the only way to have remedy. You saw in the court judgment that I read to you today, a judicial declaration is only one effect, only one way for you to obtain remedy. But it seems, as I read comments in YouTube, many people are seeking to go forward and go into the courts to try and have their full legal capacity respected. So based upon that, I will be trying to release some videos that share my knowledge.